August 19th, 1947. Late afternoon, Nuremberg in the Palace of Justice that had already heard the words crimes against humanity more times than any other room on earth. The first of the 23 defendants in the medical case stands rigid as the clerk and presiding judge begin to read the verdicts in United States versus Karl Brandt et al. The trial that will be remembered simply as the doctor's trial. The air is heavy, windows cracked, but barely letting in sound from the devastated city outside. Reporters are pressed into the gallery, pens ready, while military police line the walls, their eyes flicking from the bench to the rows of defendants in gray and brown uniforms stripped of rank. Near the front sits a man whose face many Germans once knew only from official photographs and whispered stories. Professor Dr. Karl Brandt, surgeon, SS officer, and former escort physician to Adolf Hitler. He is not in a white coat, not in an operating theater, but in headphones and a dock, one figure in a line of men accused of turning medicine into a weapon. The formal language of the tribunal rolls out over the microphones, translated into multiple languages, the same structured cadence used in earlier Nuremberg cases. Counts are summarized, legal definitions recited, the charges of war crimes and crimes against humanity tied to specific programs, euthanasia killings under Aktion T4, lethal experiments in camps, mass murder carried out under the cover of science. When the judge reaches Karl Brandt's name, there is no dramatic pause recorded in the transcripts, no theatrical monologue, just a sequence of findings. Guilty on key counts, responsible for participation in the euthanasia program and in non-consensual human experimentation. Then the sentence that matters more than any legal reasoning that led up to it, death by hanging. When the verdict was read, that was the moment it became clear Karl Brandt was going to death row. In a single sentence, the gap between accused doctor and condemned man closed forever. 7 of the 23 defendants would receive the same fate, but Brandt's name carried a particular weight. Hitler's physician now formally judged a criminal whose punishment would be the gallows. Observers note that most of the defendants tried to maintain military bearing, standing stiffly as the tribunal pronounced judgment, some staring straight ahead, others turning slightly to catch the interpreter's words through their headphones. Whatever Karl Brandt thought in that instant is not preserved in any reliable record, but the implications of the words spoken over him are brutally clear. There will be no return to a clinic, no quiet exile, no reduced sentence later on. This is the moment this story hinges on, not because it is dramatic in a cinematic sense, but because it is the point where a paper trail, years of bureaucratic decisions, and thousands of deaths converge into a single or irreversible outcome. And to understand why this one physician ended up in that dock on that day with that sentence, you have to see the mechanism that brought him there. A few lines of text on Adolf Hitler's personal stationery, backdated to the first day of the war. Before following that paper upstream, hold on to what this room represents. The doctor's trial was the first major international proceeding to put physicians on trial specifically for war crimes and crimes against humanity. Rather than treating them as incidental figures in a larger political case, it placed the medical profession itself under scrutiny and produced principles that would soon be known as the Nuremberg Code, a set of standards insisting that human experimentation required voluntary consent and that doctors could not hide behind state orders to justify killing. Karl Brandt stood at the center of that reckoning, because he embodied a particular trajectory. Talented surgeon, party loyalist, Hitler's personal doctor, and then Reich Commissioner for Health and Sanitation, with sweeping authority over Germany's medical apparatus in wartime. Under his watch, and with his name on a critical authorization, medicine in the Third Reich helped design and administer the euthanasia program that murdered tens of thousands of disabled and mentally ill people long before the gas chambers in occupied Poland reached their full tempo. So, in this video, you're going to see who Karl Brandt actually was behind the title Hitler's Doctor, how Aktion T4 operated as a secret killing program, and why historians point to a figure of at least 70 Oslauer victims in its first phase alone, the single Hitler memorandum that tied Brandt personally to that machinery, the way prosecutors used that document to strip away his defense in Nuremberg, and the exact moment when the words "sentenced to death by hanging" turned theoretical risk into unavoidable fate. You will also see how his execution at Landsberg prison in 1948 fed directly into the post-war debate over medical ethics, and continues to shape how doctors and researchers talk about consent, obedience, and responsibility today. If in-depth, document-driven breakdowns of World War II trials, war crimes, and the people who sat in those docks are the kind of history you want more of, consider subscribing for future episodes. And as you listen, use the comments to answer this. When a government orders doctors to kill and calls it legal, where do you think a physician's duty ends and criminal responsibility begins? Now, roll back almost 2 decades from that Nuremberg courtroom. Long before Karl Brandt stood in front of American judges, He was a young doctor in a country where politics and medicine were becoming dangerously entangled. Born in 1904, trained as a surgeon, he built a reputation as a competent clinician and specialist in trauma and brain injuries, the sort of physician you would expect to find in operating theaters, not in a defendant's dock. He joined the Nazi Party and the SS as the movement rose, choices that opened doors in a system where loyalty mattered as much as skill. In 1934, he was appointed as one of Hitler's escort physicians, responsible for accompanying the Führer on trips and being immediately available for medical emergencies, a post that brought him into the inner circle of the regime. That role evolved. Over the years, Brandt became not only a traveling doctor, but a trusted surgeon and advisor, part of a small group of physicians whose access to Hitler translated into influence over health policy and military medical planning. In 1948, amid the pressures of total war, he was appointed Reich Commissioner for Health and Sanitation, a position that formally placed him near the top of the medical hierarchy in Nazi Germany. From that bureaucratic perch, Brandt's responsibilities extended far beyond tending to one patient in a bunker. He was involved in coordinating civilian health measures, military medical services, and, crucially, policies that blurred the line between public health, racial ideology, and the removal of those deemed unfit. EHIDIS, the same system that organized vaccinations and hospital beds, also designed categories like life unworthy of life, and Brandt's name appears within that apparatus at decisive points. To see how, you have to understand Aktion T4, the code name used after the war for a program the regime never openly advertised. In the autumn of 1939, as the invasion of Poland unfolded, a parallel project began inside the Reich, the systematic killing of adults and children with disabilities or severe mental illness, justified internally as euthanasia and mercy deaths. Patients were identified through questionnaires, transported to specialized centers, and murdered by gas, lethal injection, or deliberate starvation in facilities disguised as hospitals. By 1941, at least 70 Yisu's people had been killed under this centralized phase of the program, and the methods and personnel developed there would later be exported to the broader machinery of mass murder in occupied Europe. The operation was organized from offices at Tiergartenstrasse 4 in Berlin, hence T4, and depended heavily on the cooperation of doctors who diagnosed, selected, and signed off on patients who were never intended to leave the institutions alive. In that context, one document stands out as the fulcrum between policy and personal responsibility. Sometime in October 1939, Adolf Hitler signed a short memorandum on his private stationery, but ordered it backdated to September 1, 1939, the day Germany invaded Poland. The text was not long. In essence, it instructed Reichsleiter Philipp Bouhler, the head of Hitler's chancellery, and Dr. Karl Brandt, described explicitly as his physician, to broaden the authority of certain doctors so that people judged incurably ill could be granted a mercy death after careful medical examination. Those few lines became the only written Führer authorization for the euthanasia program, designed in part to reassure participating doctors and staff that they would not face criminal charges under German law for killing their patients. It is not a general wartime order addressed to anonymous officials. It is a directive naming two men, Bouhler and Brandt, as responsible for enlarging that lethal authority. In the years that followed, T4 relied heavily on secrecy and euphemism. Families received letters claiming their relatives had died of pneumonia or heart failure. Death certificates were falsified. Publicly, there was no statute admitting that the state had empowered doctors to kill. But inside locked files, that single memorandum existed as a kind of legal fig leaf. The piece of paper staff could point to if anyone asked what gave them the right to turn wards into killing rooms. Decades later, historians would describe that letter as the smoking gun tying Brandt to Aktion T4, but its decisive impact came much earlier, in the Nuremberg Courtroom where you began this story. When prosecutors introduced the original document as Prosecution Exhibit US 342, they were not just presenting evidence of a policy, they were presenting a direct, handwritten link between Adolf Hitler and the doctor, now standing in the dock. For Karl Brandt's defense, which argued that he was following general wartime directives and held only limited responsibility for localized abuses, that ink on Hitler's stationery was devastating. It transformed him from another high-ranking official who might claim ignorance of details into one of the two men explicitly charged by the Führer with empowering doctors to grant mercy deaths to the incurably ill. By the time the tribunal president pronounced death by hanging in August 1947, the path from that authorization letter to the gallows had already been traced in detail across weeks of testimony and argument. The moment you saw at the start, the reading of the verdict, was the endpoint of a chain that began in a Berlin office with a brief memorandum and a signature backdated to the beginning of the war. The trial that brought Karl Brandt to that moment of sentencing began on December 9, 1946, inside Courtroom 600 of the Palace of Justice in Nuremberg, the same building where the major war criminals had been judged months earlier. But this was not a continuation of the International Military Tribunal. This was the first of 12 subsequent trials conducted solely by the United States under its occupation authority, targeting specific groups and institutions within the Nazi state. 23 defendants sat in the dock, a mix of physicians, medical administrators, and SS officers accused of participating in or organizing criminal medical experiments and mass killing under the cover of science. The charges were divided into 4 counts: conspiracy to commit war crimes and crimes against humanity, war crimes involving medical experiments without consent, crimes against humanity through those same experiments, and membership in criminal organizations. Karl Brandt was the lead defendant, listed first on the indictment as Karl Brandt, personal physician to Adolf Hitler, and Reich Commissioner for Health and Sanitation. His placement was deliberate. Prosecutors viewed him as the most senior figure in the dock, the man whose authority and proximity to Hitler symbolized the fusion of state power and medical murder. Over the months that followed, the tribunal heard 54 witnesses and examined 117 separate accusations tied to various programs and experiments. Evidence included freezing experiments at Dachau designed to test survival in extreme cold, high-altitude experiments that killed subjects in low-pressure chambers, sulfanilamide trials involving deliberate infection of wounds and bone, muscle, and nerve transplant surgeries performed on prisoners without anesthesia or consent. But for Brandt specifically, the core of the prosecution's case centered on Aktion T4, the euthanasia program that predated the concentration camp experiments and established the bureaucratic and psychological framework for later atrocities. The Hitler authorization memorandum was entered into evidence early, and its impact on the courtroom was immediate. Here was a document signed by Hitler himself, naming Karl Brandt by name and title, charging him with expanding doctors' authority to kill patients. It was not a vague reference to wartime medical priorities or resource allocation. It was explicit instruction to enable what the regime called mercy death for people judged incurable. Brandt's defense attorney, Dr. Robert Servatius, a German lawyer who had also represented defendants at the main Nuremberg trial, attempted to argue that Brandt acted under superior orders, that the program was intended to alleviate suffering in a wartime environment of scarce resources, and that Brandt personally believed he was performing a medical and ethical service by preventing prolonged suffering. Servatius tried to frame the euthanasia program as a tragic but understandable response to extreme conditions, not as premeditated murder. He pointed to testimony suggesting Brandt had tried to limit abuses, that he personally examined some cases, and that he believed the program served a compassionate purpose within the framework of National Socialist ideology. But every one of those arguments shattered against the evidence prosecutors laid out week after week. Testimony from survivors, from families who received false death notices, from whistleblowers who had tried to stop the program, all of it pointed to a centrally organized, systematically concealed killing operation that had nothing to do with individual doctors making compassionate decisions at bedsides. Witnesses described the gray buses that transported patients to killing centers, the fake showerheads and gas chambers, the crematoriums built specifically to dispose of bodies, and the falsified death certificates sent to families who were never told their relatives had been murdered under state policy. This was not euthanasia in any recognizable medical sense. It was industrial killing dressed in clinical language. And through it all, the Hitler authorization sat in the record, tying Brandt's name to the program's very foundation. The prosecution argued that Brandt was not simply following orders from above. He was one of the officials, given the authority to create and administer those orders, empowered by Hitler to expand the killing apparatus. When prosecutors pointed to the memorandum during cross-examination, they could ask Brandt directly, "Is this your name on this document? Did you accept this responsibility? Did you exercise the authority it granted?" And each affirmative answer, each acknowledgement that yes, he had been named, yes, he had participated in organizing aspects of the program, moved him closer to the sentence that would eventually be read in August. The defense could not credibly claim Brandt was a minor figure swept up in events beyond his control when Hitler's own signature placed him at the program's administrative center. They could not argue ignorance when the authorization explicitly described what doctors were being empowered to do. And they could not hide behind claims of isolated excess when the evidence showed a program that spanned multiple facilities, involved hundreds of personnel, and killed systematically over years. As the trial stretched from winter into spring and then summer of 1947, the weight of documentation accumulated. By the time closing arguments were delivered in July, the tribunal had heard enough to reach conclusions that would be read just weeks later. On August 19, 1947, the verdicts were announced. Of the 23 defendants, 7 were acquitted outright, 9 received prison sentences ranging from 10 years to life, and 7 were sentenced to death. Karl Brandt was found guilty on counts 2 through 4 of the indictment, the charges directly tied to war crimes, crimes against humanity, and participation in euthanasia and non-consensual experimentation. The tribunal's judgment, when read aloud, was clear and unsparing in its language. It described Brandt as directly responsible for the suffering and deaths of concentration camp victims used in experiments, and for his role in the euthanasia program that claimed over 70 Zoonosaur lives. The court found that, regardless of whatever internal justifications or ideological convictions Brandt may have held, his actions constituted crimes under international law. Then came the sentence that sealed his fate: death by hanging. Karl Brandt had reportedly told people during the war that he was the one German the Americans will never hang, a statement reflecting either confidence in his perceived indispensability as a physician or a fundamental misunderstanding of what awaited him if captured. That confidence, if it ever truly existed, died in the courtroom when the judge's words made execution a certainty rather than a theoretical risk. The moment was procedural, almost mundane in its delivery, but it represented the collapse of every assumption Brandt had operated under for years. He was no longer Hitler's doctor, no longer a Reich commissioner, no longer protected by the state apparatus that had empowered him. He was a condemned man, and the bureaucracy that would now take over was American military justice moving him toward a gallows. Between the August 1947 sentencing and the execution that would follow months later, Karl Brandt and the other condemned doctors had one avenue left: clemency petitions to the U.S. military governor of occupied Germany. Dozens of appeals arrived on behalf of Brandt, including letters from representatives of German churches and relief organizations. Among those who wrote was Eugen Gerstenmaier, chairman of the relief organization of the Evangelical Church in Germany, arguing for mercy on various grounds. The arguments varied. Some petitioners emphasized Brandt's medical qualifications and suggested he could contribute to post-war reconstruction. Others claimed he had been motivated by genuine, if misguided, compassion within the ideological framework he inhabited. Still, others pointed to his lack of direct participation in concentration camp killings, distinguishing him from guards or executioners who had personally murdered victims. But the final authority rested with General Lucius D. Clay, the U.S. military governor, and his response to the clemency petitions was unambiguous. In a statement that would be preserved in official records, Clay wrote that regardless of whatever internal convictions Dr. Brandt may have held, he was directly responsible for much of the suffering and death inflicted on concentration camp victims chosen for brutal medical experiments. Clay concluded that, in justice to those who had undergone torture and death, he was unable to grant clemency in the case. That decision meant the sentence would be carried out as pronounced. No commutation to life imprisonment, no reduction to a term of years, no exile or alternative punishment. The 7 doctors sentenced to death would hang. In the months between sentencing and execution, one detail emerged that captured the strange contradictions of Brandt's position. After learning his fate, he made an offer to the Allied authorities. He would donate his body to be used for medical experiments after his execution. It was either a final gesture of belief in the utilitarian logic he had operated under during the war, or a calculated attempt to reframe himself as a martyr for science, rather than a convicted criminal. The request was denied. The Allies were not interested in transforming Brandt's execution into a philosophical statement about medical research, and accepting such an offer would have created precisely the kind of moral equivalence the trial had been designed to reject. June 2, 1948. Landsberg prison in Bavaria, the same facility where Adolf Hitler had been held after the failed beer hall putsch in 1923, now served as the execution site for Nazi war criminals. All 7 doctors condemned at Nuremberg were hanged on the same day in a coordinated series of executions carried out by U.S. military personnel. Karl Brandt was among them. At the gallows, in his final moments, he made a statement that would be recorded by witnesses and later cited in historical accounts. He denounced his execution as an act of hypocrisy. The exact wording varies across sources, but the thrust was consistent. Brandt argued that the victors were judging him for actions that mirrored practices they themselves had employed or would employ, that the moral authority claimed by the tribunal was selective, and that history would judge differently. Then the trapdoor opened, and Karl Brandt, age 44, Hitler's former physician and Reich Commissioner for Health and Sanitation, died at the end of a rope. His execution, along with the others carried out that day, closed the immediate legal chapter of the doctor's trial. But the trial's impact extended far beyond the fate of individual defendants. During the proceedings, the tribunal had been forced to articulate principles that could distinguish legitimate medical research from criminal experimentation. The result was a set of 10 points that became known as the Nuremberg Code, the first international document to explicitly establish standards for ethical human experimentation. The Code's first principle was unambiguous. The voluntary consent of the human subject is absolutely essential. It went on to specify that experiments must be designed to yield results for the good of society, that unnecessary suffering must be avoided, that subjects must be free to withdraw, and that researchers must be prepared to terminate experiments if continuation would likely result in injury or death. These principles, articulated in direct response to the evidence presented against Brandt and the other defendants, became foundational texts in medical ethics. They influenced the development of later documents like the Declaration of Helsinki and continue to shape debates over consent, research ethics, and the limits of medical authority. In that sense, Karl Brandt's path from operating theater to gallows helped define the boundaries his execution was meant to enforce. The trial did not simply punish individual crimes. It created a legal and ethical framework asserting that doctors could not hide behind state authority, that medical killing could not be justified by invoking duty or ideology, and that consent was not optional. The authorization letter signed by Hitler and bearing Brandt's name, the document that prosecutors had wielded so effectively during trial, became prosecution exhibit US 342 in the permanent historical record. It remains one of the most cited pieces of evidence when scholars examine how bureaucratic structures enable atrocity, how professional authority can be weaponized, and how a few lines of official text can empower systematic murder. For the families of Aktion T4 victims, the execution brought a form of justice, the one that could never restore what had been taken. For the medical profession, the trial and its aftermath posed uncomfortable questions about how physicians in a supposedly advanced nation had participated so willingly in killing, and what safeguards might prevent future repetitions. And for legal scholars and historians, the doctor's trial established precedents about individual responsibility, the limits of the superior order's defense, and the principle that certain acts are criminal regardless of the domestic law under which they were authorized. Karl Brandt's final claim at the gallows, that his execution was hypocrisy, rested on the argument that all governments compromise medical ethics when expedient. But the tribunal's response, encoded in the verdict and the principles that emerged from it, was that the scale, systematization, and utter absence of consent in Nazi medical crimes placed them in a category that justified the term crimes against humanity. The execution of Karl Brandt and the 6 other doctors at Landsberg did not resolve the deeper questions the trial had raised. If anything, it sharpened them. Because the doctor's trial was not just about punishing individuals who had committed atrocities, it was about confronting the fact that the atrocities had been committed by highly educated professionals operating within a legal framework that their own government had created. Every defendant in that courtroom had medical credentials. Most had years of training, published research, academic appointments. They were not thugs or sadists plucked from the streets and given white coats. They were physicians who had taken oaths, who understood anatomy and pathology, who knew what death looked like because they had spent careers trying to prevent it. And then, under the Nazi regime, they had used that knowledge to kill more efficiently. That transformation, from healer to executioner, could not be explained simply by invoking Hitler's charisma or the SS's brutality. It required examining how an entire profession could be co-opted, how medical language could be weaponized to disguise murder as policy, and how the bureaucratic structures of hospitals and clinics could be turned into machinery for selecting and eliminating people deemed unworthy of life. Aktion T4, the program that Karl Brandt helped administer through the Hitler authorization, was the proving ground for many of those techniques. The questionnaires used to identify patients, the transportation networks that moved them to killing centers, the gas chambers disguised as shower rooms, the crematoriums built to dispose of bodies, and the falsified death certificates sent to families. All of this was developed, tested, and refined in the T4 program before being scaled up and applied in the concentration camps of occupied Poland. Some of the same personnel who had staffed T4 killing centers were later transferred to Operation Reinhard, the program that established the extermination camps at Treblinka, Sobibor, and Belzec. The institutional knowledge of how to kill large numbers of people quickly and dispose of their bodies moved from the euthanasia program into the machinery of the Holocaust. In that sense, the authorization letter that bore Karl Brandt's name did not just empower the killing of 70 Hohenzollern disabled and mentally ill Germans. It helped establish the administrative and psychological framework that made industrial genocide possible. That connection was not lost on prosecutors at Nuremberg. They understood that the doctor's trial was establishing a principle that would extend beyond the specific defendants in the dock. They were arguing that professional credentials do not immunize anyone from criminal responsibility, that medical expertise does not grant authority to kill, and that following orders or obeying domestic law cannot justify participation in crimes against humanity. The verdict against Brandt and the others made those principles concrete. It said that a physician who uses his knowledge to harm rather than heal, who selects victims for execution rather than patients for treatment, has committed a crime regardless of what his government authorized or his ideology justified. But applying that principle required confronting uncomfortable realities about how easily institutions can be corrupted and how readily professionals can rationalize participation in systems they know are causing harm. Testimony during the trial revealed that many doctors involved in T4 and the camp experiments had expressed doubts at various points. Some had asked questions about the legal basis for the program. Others had raised concerns about specific methods or the treatment of particular patients, but those doubts rarely translated into refusal. Instead, doctors who were uncomfortable with certain aspects of the program often negotiated smaller roles or requested transfers, allowing someone else to carry out the killing while they moved to positions that felt more defensible. That pattern of complicity through accommodation was harder to prosecute than direct participation, but the trial's evidence made clear it was part of what enabled the system to function. Karl Brandt's defense had relied heavily on the argument that he believed he was acting ethically within the framework of National Socialist ideology, that he saw the euthanasia program as a form of compassionate medicine in a time of war and scarce resources. His attorney, Servatius, tried to present him as a physician caught between competing obligations: his duty to the state, his medical judgment about suffering, and his commitment to what he understood as the greater good. The tribunal rejected that framing entirely. The judges found that no ideology, no matter how sincerely held, could transform systematic murder into medicine, and that Brandt's education and position made him more, not less, culpable for recognizing what he was participating in. When the sentence of death was read on August 19, 1947, it represented the tribunal's conclusion that Brandt had crossed a line so fundamental that execution was the only proportionate response. Not because vengeance demanded it, but because allowing him to live would have suggested that the crimes he enabled could be reconciled with continued participation in society. That judgment carried implications far beyond Karl Brandt's individual fate. It established that medical professionals have responsibilities that transcend national borders and domestic law, that the physician's duty to do no harm is not suspended by government orders, and that participation in state-sanctioned killing is a choice, not an inevitability. The Nuremberg Code that emerged from the trial made those principles explicit in the context of human experimentation. But the broader lesson was about professional ethics in general. Expertise confers power, and power without ethical limits is simply a more efficient form of violence. Decades after Brandt's execution, medical schools around the world began incorporating the Nuremberg Code and the history of Nazi medical crimes into their curricula. Students learning anatomy and pharmacology also learned about what happens when medical knowledge is placed in service of ideology rather than healing, when patient welfare becomes subordinate to political goals, and when doctors decide that some lives are worth less than others. That education is Brandt's legacy, though not the one he imagined. His offer to donate his body to medical research after execution reflected a belief that he was serving science, that his actions could be understood as part of a utilitarian calculus where individual lives mattered less than collective advancement. The rejection of that offer and his execution were both statements that the calculus itself was illegitimate. Some acts place you outside the community you claim to serve, and participation in systematic murder is one of them. When you step back from the individual story of Karl Brandt and examine the doctor's trial as a whole, what emerges is a portrait of how institutions fail when professionals prioritize obedience over ethics. The 23 defendants represented different levels of the medical hierarchy in Nazi Germany, from senior administrators like Brandt to camp doctors who conducted experiments directly on prisoners. But nearly all of them used the same defense. They were following orders, acting within the legal framework of their time, and advancing what they believed to be legitimate scientific or medical goals. The tribunal's response was to establish that those justifications were legally and morally insufficient. The Nuremberg Code's insistence on voluntary consent was not just about protecting research subjects, it was about rejecting the claim that doctors could be mere instruments of state policy. By requiring consent, the Code reasserted the patient's humanity and the physician's obligation to treat each person as an end rather than a means. That principle sounds abstract until you consider what it meant in practice. Under Aktion T4, patients were never asked whether they consented to being killed. They were evaluated, selected, transported, and murdered without any input into the process. Families were informed only after the fact, through letters containing fabricated causes of death. The entire apparatus was designed to eliminate the patient's voice, to reduce human beings to administrative problems that physicians and bureaucrats could solve through paperwork and gas chambers. Karl Brandt's role in that system, documented through the Hitler authorization and his administrative actions as Reich commissioner, made him one of the architects of that silencing. When he stood in the dock in Nuremberg, the prosecution's case rested on showing that he had not merely followed orders, but had helped create the machinery that turned medical facilities into execution sites. After the executions at Landsberg, the 9 defendants who had received prison sentences served varying terms. Some sentences were reduced during the appeals process, reflecting ongoing debates about proportionality and the complexities of assigning individual responsibility within a massive criminal enterprise. But the 7 who were hanged, including Brandt, remained symbols of a boundary the Allies had drawn. Certain crimes, even when committed under state authority, warranted death. That boundary has been contested ever since. Some critics of the trial have argued that imposing capital punishment on physicians, regardless of their crimes, violated the principle that medical professionals should not kill. Others have pointed to inconsistencies in how different Allied powers treated medical war criminals, with some Soviet and British trials producing different outcomes for comparable offenses. But the core legacy of the doctor's trial is not the specific sentences handed down in 1947. It is the establishment of principles that have shaped medical ethics, research regulation, and human rights law for nearly 8 decades. The Nuremberg Code influenced the development of institutional review boards that evaluate research protocols, informed consent procedures that are now standard in clinical settings, and international agreements about the limits of medical intervention. Every time a patient signs a consent form, every time a researcher must justify an experimental protocol to an ethics committee, every time medical students learn about the obligation to do no harm, they are encountering ideas that were formalized in response to the evidence presented against Karl Brandt and his co-defendants. That does not mean the lessons have been perfectly applied. The history of medical ethics since 1948 includes troubling episodes where consent was compromised, where vulnerable populations were exploited for research, and where physicians prioritized scientific advancement over patient welfare. The Nuremberg Code established a standard. It did not automatically create compliance, but it did create a reference point, a set of principles that could be invoked when abuses were discovered, and a framework for arguing that certain practices were unacceptable, regardless of their purported benefits. In that sense, Karl Brandt's execution was not simply punishment for past crimes. It was a statement about future expectations, a declaration that the international community would not tolerate the kind of medical killing and experimentation that Nazi Germany had normalized. The moment in the courtroom when Brandt heard his death sentence, the instant when death by hanging stopped being a theoretical possibility and became his immediate future, was the culmination of choices he had made over years. Not just the choice to accept the Hitler authorization, though that was decisive, but earlier choices to join the Nazi Party, to become an SS officer, to accept positions of increasing authority within a regime whose ideology explicitly rejected the equality of human life. Each of those choices had seemed defensible at the time, at least to Brandt. Many German physicians made similar decisions, seeing opportunities for career advancement, believing in aspects of Nazi ideology, or simply accommodating themselves to the political realities of their environment. What distinguished Brandt was the level of authority he achieved, and the directness of his connection to programs that killed systematically. The authorization letter made him more than a collaborator. It made him an architect. And when the reckoning came in Nuremberg, that distinction mattered. The trial established that proximity to power increases rather than diminishes responsibility, that high-ranking officials cannot claim they were merely following orders when they had authority to shape what those orders meant, and that professional expertise does not grant immunity from prosecution for crimes committed under its cover. Those principles outlasted Karl Brandt. They informed subsequent war crimes. Tribunals, from the trials of Japanese medical personnel who conducted experiments in occupied China to more recent prosecutions of doctors who participated in torture or genocide. The doctor's trial became a template for arguing that medical professionals have obligations that transcend national law and that participation in state-sanctioned killing is a crime, not a duty. When historians analyze why the doctor's trial resonated so powerfully beyond even some of the larger Nuremberg proceedings, they often point to the betrayal it represented. Soldiers commit violence. That is, in a terrible sense, expected during war. But physicians are supposed to heal. The entire structure of medical training, from the Hippocratic tradition through modern medical education, is built on the principle that doctors exist to relieve suffering, not inflict it. The Nazi medical crimes shattered that assumption. They showed that healing and killing could coexist within the same institutions, that the same hands that performed surgery to save lives could also perform experiments designed to cause death, and that medical knowledge could be turned toward destruction as easily as toward cure. Karl Brandt embodied that contradiction. A trained surgeon who used his expertise to administer a killing program that claimed over 70 Zero Noir's lives. The tribunal's verdict of death made clear that you cannot be both healer and executioner. That judgment shaped decades of medical ethics regulation, licensing boards that screen for ethical violations, research review committees, and international law governing medical conduct during conflict all trace back to this trial. The execution at Landsberg on June 2, 1948, closed Karl Brandt's story but opened ongoing debates about medical responsibility, professional ethics, and the limits of state authority over individual conscience. Those debates continue in contemporary discussions about physician-assisted suicide, about experimentation on vulnerable populations, about medical care in detention facilities, and about doctors' obligations when state policy conflicts with patient welfare. Each of those debates, whether participants realize it or not, is informed by the precedents set in the doctor's trial. The questions asked then remain relevant. What do physicians owe their patients that transcends what governments demand? When does following orders become participation in crime? At what point does professional authority become professional responsibility for harm? Karl Brandt's answer to those questions, reflected in his actions between 1939 and 1945, was that state authority superseded individual ethical judgment, that the physician's role was to serve the regime's goals, and that categories like life unworthy of life were legitimate medical determinations rather than genocidal ideology. The tribunal that sentenced him to death rejected every element of that position, and in doing so, it established that medical ethics are not culturally relative, that human dignity is not negotiable, and that physicians who participate in systematic killing are criminals regardless of what legal cover their governments provide. Return now to that courtroom on August 19, 1947, the moment when Karl Brandt, standing in headphones in the Palace of Justice, heard the words that ended any hope of survival. Not a dramatic moment in the cinematic sense, no shouting or collapse, just the formal reading of a verdict that transformed him from defendant to condemned man. That transformation happened in seconds. The gap between accused and sentenced to death was the length of time it took to read the judgment. But the distance Brandt had traveled to reach that point stretched back through years of choices, through the T4 program and the authorization letter bearing his name, through his elevation to Reich commissioner and his proximity to Hitler, through all the moments when he could have refused or resigned but chose instead to continue. The verdict made explicit what the evidence had already shown, that those choices had consequences, that authority brings accountability, and that some crimes are so fundamental that only the most severe punishment is adequate. When the trap door opened at Landsberg and Karl Brandt fell, he carried with him the era's belief that medicine could be subordinated to ideology, that physicians were instruments of state policy, and that some lives mattered less than others. The Nuremberg Code that emerged from his trial and the others represented the international community's attempt to ensure those beliefs died with him. Whether that attempt has succeeded remains an open question. Medical ethics violations continue. State-sanctioned torture still involves physicians. Experimentation on prisoners and vulnerable populations has not disappeared. But the standard established at Nuremberg endures as a reference point, a set of principles that can be invoked when abuses occur, and a reminder that physicians have obligations that no government can override. So here's the final question, the one that matters more than historical detail or legal analysis. If you were a physician in a regime that asked you to participate in determining which patients deserved treatment and which deserved death, that provided legal authorization for your actions, and assured you that you were serving the greater good, would you recognize the moment when medicine stopped and murder began? Karl Brandt apparently did not, or he recognized it and chose to continue anyway. The verdict read against him on August 19, 1947, was the world's answer to that choice. The gallows at Landsberg on June 2, 1948 was the final punctuation, and the question he failed to answer correctly remains open for every physician, researcher, and medical professional who will ever face the choice between what their government demands and what their oath requires. That is why the one moment Karl Brandt realized he was going to death row matters beyond his individual fate. It marks the point where the world said certain lines cannot be crossed, certain crimes cannot be excused, and certain betrayals of professional duty warrant the ultimate penalty. The moment the verdict was read, everything changed for Karl Brandt. But the principles established in that courtroom were meant to change things for everyone who would come after. If you found this deep dive into Karl Brandt's trial gripping, hit subscribe for more WF2 medical war crime stories. Where would you draw the line between a doctor's duty and state orders? Drop your answer below. I'll see you in the next one.